crime and due process. Again, beginning a new video on this, kind of separate the two. So crime and due process. You take a look at the amendments that deal with crime and due process. Fourth Amendment, unreasonable search and seizures. Fifth Amendment, not have to testify against yourself, etc. There is a central problem in interpreting provisions of the Bill of Rights that deal with criminal rights. The court has had to decide what those rights mean, and how best to put them into effect. So, if you take a look at those amendments, the amendment does not say what constitutes an unreasonable search and seizure. Further, the amendment does not say if an unreasonable search and seizure is committed, how do we enforce that? How do we prevent that from happening? Or if it does happen, what is the remedy? So it's not obvious as to what constitutes an unreasonable search and seizure. So the court has had to decide. And then what happens when it happens? What happens when an unreasonable search happens? What should be the remedy? So you have, again, going back to the beginning of this chapter, we have certain rights in conflict. You would think there would be no unreasonable searches and seizures, but we have this right of society's right to order versus the individual's right to their personal freedom and liberty and to be secure in their persons, papers, houses, and effects. Okay, so there's some conflict, some competing interests here that are taking place, which make this a little sticky. All right, so what constitutes an unreasonable search? Most nations, when an unreasonable search takes place, they punish the police who have illegally obtained the evidence. But, and this is a big but, they allow that evidence in court. The U.S. decided, in this case of Mapp versus Ohio, they decided that they weren't going to do that. So this is a case, this is when, in that whole process of incorporation, the Fourth Amendment right to unreasonable searches and seizures was imposed upon the states because of the 14th Amendment's due process clause. So the court had to decide if the state government or if the federal government, there was already a rule in the federal government. So if the state government conducted an unreasonable search and seizure, what were they going to do? And what they decided they would do was they would exclude it from the trial. So if police obtained information or evidence illegally, it did them no good because the courts would just not permit that in a trial. The exclusionary rule, right here, right? So the courts wouldn't allow that. So what happened in the Mapp case, it was Dolores Mapp. The court went in looking for one thing, and what they found was they found a bunch of pornography, and so they arrested her for that. And they basically just ransacked the place. And not only that, they didn't even have a valid search warrant. They had forged this search warrant. So they ransacked her apartment, found these obscene pictures, and arrested her. And so the court, this was an easy case for the court. But what they did to make sure that the police didn't do that kind of stuff anymore, they said, okay, we're just going to kick it all out of court. So this exclusionary rule, the beautiful thing about the exclusionary rule, as opposed to the way most European nations do it, is there's no advantage for the police to do this because that won't be allowed into court anyway. So as we said, it was applied through the incorporation doctrine and imposed on the states. So today, what can the police search? So they can search under three circumstances. When they have obtained a search warrant issued by a judge based on probable cause, which is the good reason to believe that a crime has been committed, and the search warrant is going to describe the places to be searched and the things to be seized. So this can't be just based on a hunch. Well, Your Honor, I think this guy may have done it. I got a sneaking suspicion. Not good enough. You've got to have some evidence, an informant. Somebody saw him going at this place and then leaving at the same time the crime was committed. this search warrant will not allow them to search everything. So if you're searching for a car, you could search in somebody's backyard, you could search at their place of business, you could search in their garage. You could not search in their house, unless, of course, they had a door that was big enough to get a car through. So it will not allow anything. And then on the other hand, if you're searching for drugs, there's almost no place in somebody's house or business that you wouldn't be allowed to search, as long as you had probable cause to do it. When you are arrested, the police can search you and the things under your immediate control during a lawful arrest. So if you get arrested, you're in a car, the police are going to be able to search your car. And finally, the police can search you if they have probable cause to believe that you have committed a crime. Usually that's going to be a felony. So that's when they can search. Okay, so during the arrest, as I was saying, they can search you, things in plain view, and things under your immediate control. So if you're in a car, can they make you open the trunk? Absolutely, because that is something in your immediate control. So they're going to be able to do that. All right, final slide. Fifth Amendment and the right against self-incrimination. Fifth Amendment is a major right in the United States, and which has been imposed again on the states by the incorporation doctrine. In Miranda versus Arizona in 1966, I was 4 years old at the time. Don't remember anything about it, but I do remember later on in life, not too much later, the noise, so to speak, that it made. People thought the ruling had gone too far. In retrospect, I think it was a really good ruling. So Ernesto Miranda was a high school dropout. There was a rape. A girl got raped. She said to the guy who raped her, "Hey, I've had a tough day. I've had a tough day with this." She goes, "Can you at least drop me off near my house?" And so the guy did it. I dropped her off a couple blocks from her house. She went in, called the police, described the guy who had raped her, described the car that he drove, and the police knew exactly who this was based on her description and based on the car he drove. And so they went and arrested Ernesto Miranda. While they were arresting him, they never advised him that he had a constitutional right to remain silent. He was a high school dropout. And so he didn't know he had a Fifth Amendment right and he had the right to remain silent. He confessed to the crime and obviously then was convicted. So on appeal to this conviction, his lawyer argued that his interrogation had violated the Constitution because he was a high school dropout. He just didn't know he had the right to remain silent. And so this case went all the way up to the Supreme Court. And the court basically required, after the Miranda case, what became known as the Miranda warnings. What they said was when police arrest someone, they have to advise them of their rights. They have to advise them they have the right to remain silent. Anything they say can and will be used against them in the court of law. They have the right to an attorney. If they cannot afford an attorney, one will be appointed for them. They have to tell them. And if they don't tell them anything they say, their confession is illegal and can't be used in court. So today, police departments have a card, or what's called a Miranda card, and they just read the rights to the defendant and then have the defendant sign. And so the defendant knows if he doesn't say anything, it's okay. If he says something, it can still be used. Now, originally, this right against self-incrimination was intended to prevent torture to extract a confession. So if you look at this, we don't want the government putting somebody on the rack and tearing them apart until they confess, because then people will confess to anything whether or not they've done it. So not a good idea. Nevertheless, the intent, what the Supreme Court has ruled, the intent of the Fifth Amendment was testimonial in nature. So what it was trying to prevent was the government from extracting confessions. So if you look at fingerprints, do they violate the Fifth Amendment? The Supreme Court has said no. Blood, semen, hair samples, etc. They do not violate the Fifth Amendment because the Fifth Amendment was intended to have a testimonial protection. The government forcing you to say something. This new dynamic of wherever you go, you leave a trail, that is not part of the Fifth Amendment right against self-incrimination. So today, can they force you to give your fingerprints? Yes. Can they force you to give blood, semen, and hair samples? Yes. They can do all that. All right. To finish off this chapter, one last story that goes back to Miranda versus Arizona. One of the great ironies of history and law here. So Miranda, he goes to court again. So there was a second trial. At the second trial, the state of Arizona could not use his confession to help convict him. Nevertheless, he was convicted anyway. And he went to jail for a number of years, and he got out on parole. And while you're on parole, it is illegal to go to bars. Because when you drink, in many instances, you do stupid things. And so Miranda's on parole, and what does he do? He goes to a bar anyway. And he starts drinking, and he starts doing stupid things, including getting one of the fellow patrons upset with him. And Miranda and this guy started to fight. And it got really bad. And so the employees at the bar called the police, and this guy who was fighting Miranda got the upper hand, and he was just beating the tar out of him. By the time the police got there, Miranda was lying on the floor dead. Dead. The guy who killed him is being held by other patrons of the bar, and the police come. They arrest the guy who killed Miranda, and you guessed it, they read him his Miranda rights. If that is not irony, nothing is. Nothing is. All right, I hope this has been helpful. If you guys have any questions, again, send me a text, or send me an email, and I'll help you out.